let's start our webinar that is hosted by our Ukraine program. Today we have two distinguished, amazing experts on the topic of the webinar. Thank you so much for joining, Margarita Sokorenko and Tamar Tomashvili. We really appreciate that you found time to be here regardless of your busy schedule. So today we will be discussing the recent admissibility decision issued by the European Court of Human Rights concerning the case of Netherlands and Ukraine versus Russia, which is also known as the Eastern Ukraine and MH17 flight. I would like to invite Margarita, since she's the agent for Ukraine at the European Court of Human Rights, to help the viewers get a bit of an idea about the context, especially that the events have been taking place since 2014. And then Tamar, who is an IHL expert on Ukraine at the International Development Law Organization, will also provide some insights regarding legal issues that we see in the decision. If both of the speakers are ready, I will invite you to start your presentation. Margarita, it would be fine.
Mm-hmm.
Thank you so much. The floor is yours.
Anna, thank you, and hello to everyone from Kyiv, Ukrainian capital. First of all, I want to thank you, the organizers, for this event. It's quite important event, and the discussion of the decision on the European Court of Human Rights, and also would like to welcome all attendees who are following us today. As Anna told, I will provide some overview of the decision on the European Court of Human Rights on admissibility, Ukraine and the Netherlands versus Russian Federation. As a lawyer who is working with this case from the very beginning, from 2014, I can say that for our team, for the Ministry of Justice team, it's a huge victory, and also it is a very important decision for Ukraine and for the strategy of legal strategy of our state regarding the Russian Federation. Since the case is very voluminous, as you can recall, it consists of hundreds of pages. I just will point out the most important aspects of the decision that are quite important for us from practical point of view. And I also will be very glad to hear thoughts, questions from your perspective to discuss them. And if some issues I will not be able to address at this moment, you can also free to write me, and I also open to continue communication. Regarding the decision on admissibility, as you can recall, this proceeding is related to 3 interstate applications, and at the moment of delivering of the decision by the court in January this year, that case included 3 applications. The main one that related to Ukraine versus Russia regarding Eastern Ukraine, and that the proceeding started in 2014 when we submitted the first application against the Russian Federation. In fact, when Ukraine for the first time applied to the mechanism of interstate application before the European Court of Human Rights, and that application concerned human rights violations on occupied territories of Crimean Peninsula and certain areas of Donetsk and Lugansk regions. And in 2016, the European Court of Human Rights decided to separate that application for the more effective consideration of the application. And then we received two separate applications, Ukraine versus Russia regarding Crimea, and we also have the admissibility decision in that case, and the second one, Ukraine versus Russia regarding Eastern Ukraine. Also another case, it is related to the cases of kidnapping of orphan children, and they are transferring to the Russian government on several occasions in 2014. And the last one case that was joined to the proceeding in 2020. It was the application of the Netherlands versus Russia related to the MH17 crash. So the case is very voluminous, include a lot of important legal and circumstantial facts. Ukraine complained about alleged ongoing administrative practice of human rights violations under a number of articles of the European Convention on Human Rights. Almost all of them the court declared admissible. And there are several important, I can even say, key aspects of the decision that I wanted to underline and that are important for further proceeding, because now this is just the first step. We received the admissibility decision, and now we are in the stage of the consideration of the case on the merits. The court in its decision established very crucial factual circumstances. Another point is that a lot of important legal issues were examined by the court, and important findings the court indicated in the decision. And first of all, it concerns the extraterritorial jurisdiction of the Russian Federation and its effective control over occupied territories, and also legal issues regarding admissibility of complaints, especially those that are related to the admissibility of complaints regarding the MH17 crash, and examination of the Russian government, whether those complaints are admissible or not. And another important part and important findings, I think, of this case is that the court also indicated about the purpose of the mechanism of interstate applications in general. It is first of all, it is should be noted that the court underlined in this decision the role of a mechanism of interstate application, not only regarding the human rights violations, like some different separate situation, but a role of interstate application in protection of public order in Europe and collective enforcement of convention rights. This is the main one of the main goals that the convention was created, and the European Court has the one of its main role in examination of the cases. Also, another important point in this decision is that the court not just limited itself to the events in Eastern Ukraine, but while deciding the case, the court also took into account the overall context of the case, and also indicated that besides that application, there are also other 5 at that moment. There was 5 interstate applications regarding events in Ukraine starting from 2014, and moreover, the court also took into account that there were thousands of individual applications pending before the court in this respect. Another quite important and maybe the main part of work of Ukrainian team was related to the part of jurisdictional issues and establishment of effective control of the Russian Federation. And the court in this judgment confirmed that it was proven that Russia obtained effective control of the relevant part of the occupied parts of Donetsk and Lugansk regions, and moreover, it indicated the date when the Russian government obtained that effective control. The court indicated the date 11 May 2014. As you can recall, 11 May 2014, it was the day when so-called Donetsk People's Republic and Lugansk People's Republic carried out so-called referendums for their independency, and the court indicated that from that date, the Russian government, the Russian Federation is responsible, obtained effective control, and that means that human rights violations that occurred on the relevant territories, they are attributable to the Russian government. It is also quite important and interesting, the main evidence and the main points the court examined, and in order to establish the existence of that effective control. If according to the European Court of Human Rights case law regarding the extraterritorial jurisdiction issues, the court take into account several aspects. First of all, it is military presence and military involvement. Another important influence is political, economic, and all these aspects, all these criteria were established by the court in its judgment. In particular, the court indicated that starting from 11 May 2014, the Russian government received effective control on account of its military presence in eastern Ukraine, and given the decisive degree of influence as regard over those territories that were under control, so-called DPR and LPR. Moreover, the court also indicated that Russian government provided extensive, significant, and decisive political and economic support during communication with the court regarding the admissibility stage. Ukraine provided numerous evidence, not only about military presence or military coordinations or presence some so-called Russian military instructors on the occupied territories, but also a lot we managed to obtain a lot of important evidence regarding economic, financial, first of all, financial support. Almost all part of the budget of so-called DPR, LPR, they were financed from the budget of the Russian government. It also established that fact, and also Russian government politically supported DPR and LPR, and including on the international stage that was also established by the court according to the evidence we provided during the admissibility stage. Another important evidence the court took into account is that the Russian military or some Russian prominent some Russian militaries were acting within bodies created by so-called DPR and LPR. Also, Russia provided weapons and military equipment, and including the Buk missile system that was used to shut down the flight of 1717. Also, Russian government carried out artillery attacks upon requests from the DPR LPR. In this regard, it's also during May, June, July, August, we can also remember that Ukrainian eastern territory of Ukraine, that they were under constant artillery attacks from the territory of the Russian Federation. So there were the main criteria the court took into account while deciding the issue of effective control and extraterritorial jurisdiction of the Russian government over eastern regions of Ukraine that were occupied from 2014. And also two important points that in this regard, though the date of the effective control is indicated 11 May 2014. The court also indicated that it was established and proved by Ukraine that Russian military personnel was actively present in eastern Ukraine in April 2014. And another important part that the court also indicated that the Russian effective control started from May 2014, and it still continues. It indicated that at least it's up to 26 January 2022. But it doesn't mean that after this date, Russian government does not have that effective control. It just means it just means that 26 January 2022 it was the last date when during the admissibility stage the court received additional evidence of existence of that effective control. If you can recall, it was the date of hearing on admissibility of the case 2 years ago. Yes, it was 2 years, 1 year ago. Important, and this part is also important, this finding for Ukraine, because this finding opened the possibility for the court to join another interstate case to the Donbas, to the case Ukraine and the Netherlands versus Russia. 1 month ago, the court decided to join to this proceeding new Ukrainian interstate case that is relating to the new stage of the Russian military aggression against Ukraine. It's Ukraine versus Russia number 10 regarding the full-scale invasion. The interstate application that was submitted, the proceedings started on the 1st March 2024. So the cases, so now the case Ukraine and the Netherlands versus Russian Federation includes 4 interstate applications. And now we are in the active stage of the consideration of the case on the merits. And legal issues, if you can see even the legal summary, not even all the decision, the most important part is that the court declared admissible the alleged Ukraine and the Netherlands complaints regarding administrative practice of human rights violations. It's also important because it means that we managed to prove even at the admissibility stage that there is the system, the practice, the tolerance of the Russian government regarding the human rights violations of on the occupied territories, now we proceeded to new stage of our work in this case. The court has very progressive approach to the merit stage in this case. I think this year will be very active in different procedural issues, and for example, several hours ago, the court informed us that in this case, the court decided to grant the request of 27 European countries to join to the case as third parties. So now we have like a coalition in that application, and support of our European colleagues. And we are now in active process of gathering the evidence, now not about the involvement of the Russian government to the human rights violation, because it's already proven, but to the human rights violation, that's administrative practice that unfortunately Ukraine is facing, and our people are suffering from starting from 2014. It was like the main points I wanted to point out regarding our from my perspective as practicing lawyer in this case, and I will be very glad to hear your thoughts, reflections, recommendations, questions regarding it. Thank you so much.
Margarita, thank you so much. Sorry. Okay, so thank you very, very much, Margarita. It was very insightful. And I'm sure, as I told you before, there are very few people that can provide better inside information than you, since you're the one who's the agent for Ukraine. It's been really very interesting and informative. So thank you very much for that. At the same time, I would like to invite the participants to ask their questions during Q&A. That will be the last part of the webinar, right after Tamar gives us her opinion and shares her expertise regarding the legal issues that we see in the case. So I see already some things written there in the Q&A box. So again, the attendees are welcome to post their questions in the Q&A box that is separate from chat. However, any form you find more convenient would be acceptable, because I'm sure there will be a lot of questions regarding this case. Thank you once again, Margarita. And if Tamar would like to start, the floor is yours.
Thank you, Anna, and thank you, Margarita, for a very good introduction of the decision. I'm audible, right? I can continue with no problem. I think today is something extraordinary day, because we are discussing the decision of the European Court of Human Rights, and 4 minutes as we were into the session, an email popped up in my inbox showing that the International Criminal Court has issued arrest warrants with respect to the incumbent president of Russian Federation, as well as the Children's Ombudsman of the Russian Federation, in relation to forced deportation and transfer of Ukrainian children. I think it's the momentum where we see that the justice served and seen, and I hope to see a continuation, effective continuation of that case before the International Criminal Court. Putting that aside, what I will try from my perspective is to try and look at the issues raised by Margarita from two perspectives. Since the European Court of Human Rights is limited to interpret the issues from the human rights perspective, I would like to look at some of the issues from international humanitarian law perspective in parallel, and how it can influence the issues and developments at this moment. And second, to do some reflection on the use of IHL for the interpretation of the human rights law. I think before I start, I would have to say that I am presenting in my personal capacity and not as an organization who is advising the Office of the Prosecutor General of Ukraine. as well as I'm not presenting some of the reflections related to Georgia versus Russia in my previous capacity as also the representative of the government of Georgia. Therefore, please do not equate that to any positions of IDLO or the government of Georgia. What I think is the most commendable at this moment when we look at the decision of the European Court of Human Rights, I think it is taking in my humble opinion, a right direction on the evaluation of the facts and the existing, perhaps, information in order to qualify the situation. And unlike in any other cases, particularly if we look at also at Georgia versus Russia, we haven't seen such a profound discussion by the court. And I think it's the first time in reality, if we do not take into consideration the case law of International Court of Justice or ad hoc tribunals, where we see a discussion, although for the jurisdictional perspective, but in relation to attribution of the actions of non-state entities to the state, particularly when we are discussing about the actions of LPR and DPR and how they are dependent on the Russian Federation, which is would be very relevant, I believe. And again, I'm not familiar with the submission of the Ukrainian side before European Court of Human Rights, apart from what we can see in the decision on the merits when the discussion relates to individual violations, whether it's committed directly by the Russian soldier or whether it's committed by the members of LPR and DPR forces, because let's say a classification of the situation by the court in relation to the facts in 2014 has given a ground which I think will be very interesting and important when we talk about the attributability of the violations and the public international law perspective as well. Now, for me, what was I think very interesting from the decision is looking at the chronology, which also Margarita noted, is that the court engaged into giving the facts, quite often having an inference, and it is also, I think, the highest standard of inference I have observed, at least in interstate applications, where, of course, due to the fact that the Russian Federation did not, respondent state did not submit the information, but also giving a logical conclusion based on the reports of international fact-finding missions, as well as other mechanisms on what is the relationship between LPR and DPR, like composition, political situation, and military relationship between LPR, DPR, and Russian Federation. I think also what is interesting for me from the perspective of, if we are looking to the facts of the summer 2014 from the IHL perspective, is how the facts outline and give us opportunity to argue whether there has been an occupation from the perspective of IHL. Because, of course, the European Court of Human Rights talks about the effective control of the territory, which can be done by the deployment of the its troops extraterritorially, which is a classical example, or it can be done with the deployment of the Russian troops. And as Margarita mentioned, there are episodes also in the decision in relation to April and August, where there has been evidence of Russian soldiers being present there in 2014, with very specific episodes. Then in 2015, Russian soldiers being even detained in the eastern Ukraine, who were not supposed to be present there after the September 2014 ceasefire, which gives us a good indication from the IHL perspective to discuss the existence of the effective control of the territory by the presence of the troops, which would give us opportunity to discuss that there is an occupation. Now, of course, it is something which I would say is not something directly within the jurisdiction of the court, and the court would look at it from its jurisdictional perspective, as it has rightfully done, looking at the not only the presence of the forces, but also basically evaluating the dependence of LPR and DPR on the Russian Federation in order to argue that due to this dependence of the so-called local administration in the eastern Ukraine, there was actually the effective control of the territory for the purposes of exercising the jurisdiction. And I think it's a good start, particularly when we talk about the broad violations, number of violations that are present throughout the events from 2014. But there is also a second part of the issue which relates to the conduct of hostilities. And I believe it is yet to be seen how on the merits case, the merits part, the court will approach some of the issues related to the conduct of hostilities. And here I will try to maybe step back from the episode of Ukraine and Netherlands versus Russia, and perhaps look at what we had until now, before European Court of Human Rights. And I think the unfortunate experience of my country had been with the Georgia versus Russian Federation, where perhaps regretfully, or maybe due to, I don't know, readiness of the court, or even the understanding that there was a lack of information, the court did not engage into the substantial discussion similar as we see in this decision about interdependence of the de facto South Ossetian forces and Russian Federation preceding the 5-day active conduct of hostilities. And due to this fact, we ended up having a decision in Georgia versus Russia, which is somehow from the jurisdictional perspective has been, if I may say, weird. On one hand, the court considered that there was a responsibility of the Russian Federation where the jurisdiction was established through the authority of the agents when the persons were physically controlled by the Russian soldiers in the territory in 2008, basically from August 8 until August 12, which is one of the ways of the jurisdiction. However, at the same time, when the court was referring to the shelling and artillery attacks, which was taking place in Tzhinvali, basically the conduct of hostilities, the term used is active phase of hostilities. The court opted out, saying that with respect to the right to life, it would be difficult to, in the context of the chaos, actually to discuss about the negative obligation and of the Russian Federation, and merely limited its evaluation with respect to fact that there was a positive obligation of investigation. And this was primarily done by the understanding of the court that during the active phase of hostilities, it is very difficult to realize who is responsible for alleged violation of the right to life during the targeting. This is the first observation. And somehow even the court hinted in a very famous phrase that in such situations, when we talk about the right to life, actually international humanitarian law, IHL, is lex specialis. Now, putting that aside, which has been a discussion which actually renegated a lot of discussion among a lot of scholars, among the practitioners, whether it wasn't a correct approach by the court, because basically indirectly, again, in my humble opinion, the court said that in that moment, the convention doesn't protect people. I think the good start in the new case in Ukraine and Netherlands versus Russian Federation is that somehow I have a feeling that the court is trying to avoid the decision in Europe that was in Georgia versus Russia too, and perhaps it will come up with a different solution. And there is already a certain understanding from the court that it's trying to differentiate the situation in Georgia and the situation in Ukraine. For example, a very classical episode of the differentiation is when we talk about MH17. Margarita also mentioned. If you read the decision, it's very interesting that the court even makes a difference between the episode in Georgia versus Russia and the air missile attack by bookteller in Ukrainian case, saying that there was much more evidence to see who was responsible and also to attribute the responsibility to the Russian Federation, partly due to the fact that was available through the facts given by JIT, Joint Investigative Team, responsible to look into the shutdown of MH17. So I think one observation in this relation, which I think is very positive, is that perhaps we will see a little bit shift in the on the merits case, how the court will be looking at the right to life interpretation in the conduct of hostility situation, because although MH17 is different, and really it was in an area, basically a missile attack towards a civilian plane, not in the context of active phase hostilities, but itself the missile attack was targeting exercise, which differs from the situation in Georgia versus Russia. But I believe we all agree with other incidents, and there has been episodes of also targeting of Mariupol in 2015 already, which is also noted in the decision, as well as with ongoing active phase of hostilities right now in eastern Ukraine. It will be inevitable that the court will have to address this issue. And I think it's one of the challenging issues compared to other aspects. When we talk about the detention, when we talk about ill treatment, where we have the situation where the Russian soldiers or the LPR, DPR, which are under the control of the Russian Federation, are physically restraining the persons. That's why they have the obligation and they will be responsible for these actions, or where we have the effective control of the Russian Federation over the territory, where again, the obligation would be directly applicable to respect and ensure respect of the Human Rights Treaty. A second observation, perhaps, and briefly in relation to IHL, is that I think also the decision gives us an opportunity to think about the status of LPR and DPR forces. As you know, if they are belonging to a party to the conflict, that would be the Russian Federation, it will be also interesting from the IHL perspective to look at their status. Would they be the members of an armed group who belong to the Russian Federation and thus should be granted a POW status, prisoner of war status, or they are still considered as a separate non-state armed group? I believe in my personal capacity it will be first, even though that they might be violating the laws and customs of war and thus can be prosecuted for war crimes, even though they might be also engaged in terrorist activities and thus can be prosecuted for acts of terror, including acts of terror as part of the war crimes. But it also gave the facts which are given in the decision, give us opportunity also to look at the status of the parties to the conflict from 2014, not only now, but also from 2014, whether we have a situation of international armed conflict or there was two parallel armed conflict that is often discussed, the international armed conflict between Russian Federation and Ukraine, and then Ukraine fighting with two non-state actors. Last but not least, I think also this decision would be instrumental and contributing to a third aspect, and I will stop after this. This is using IHL to interpret human rights rules. This is not something new for the European Court of Human Rights. Already before even the cases of interstate litigation by Georgia, or even if we go to one of the oldest cases where the IHL was applied, and that's the case between interstate litigation between Cyprus and Turkey, already the court has engaged into interpretation of the human rights through IHL norms. And I think this would be also a situation where we would see a further development in this direction. Again, if I go back to, not to bring a new fact, if I go back to episode with MH17, which could be discussed from the human rights perspective of right to life, I believe it's very direct and obvious. It will be interesting also to look how the court will engage using the IHL principles, because the issue that will emerge, for example, from the IHL perspective, and we will see the interpretation, would be the principle of precaution. Because here we know that they were thinking that they were targeting a military, for example, the facts of the case, and correct me if I'm wrong, Margarita, but as far as I remember from the decision, the challenge was that they were thinking that they were targeting the military plane, and it turned out to be civilian. So it will be not the question of the targeting from the proportionality perspective, but it will be a question of the targeting, whether for the IHL purposes, whether they took relevant precautions before carrying out this attack. And that's something which exists under IHL, and it should be triggered into the evaluation of the Article 2 of the European Convention on Human Rights. I think I'm going to stop here. Otherwise, I will continue speaking a lot, and perhaps we'll give the opportunity for the questions.
Thank you so much, Tamar. It was very interesting, and I would definitely not want you to stop talking if we didn't have time limitations, because it's been very, very informative. Especially, thank you so much for providing your analysis from the IHL point of view. I think it was really important to consider the fact that in this case, the ECtHR not only focused on human rights law per se, but given the circumstances and the necessity also to sort of interpret IHL, to incorporate the interpretation of IHL in the case, is something really important. It was also very interesting to listen to you compare this specific admissibility decision to the Georgia versus Russia cases, where the court didn't go that far. And also, thank you very much for giving your opinion regarding the implications that this case might have. I would like to proceed now to the Q&A section, but if I may, I will begin with the first question. That would be, what do you think, even though Tamar talked about it already, but I would also love to hear Margarita's opinion, for example, what could be the potential outcome of the case and how it might affect the court's jurisdiction further. So, for example, if we establish this precedent that might, and I hope will be different from the outcome in the Georgia versus Russia case, especially as far as the interpretation of legal issues related to IHL go, how can it impact further development of these interstate applications? But I will also unite this question with something that Yaroslav asked in the Q&A box. Thank you for the interesting question, Yaroslav. So the question is, and since no speaker is specified, I would like to ask both of the panelists to provide their opinion to the extent that they deem necessary. Yaroslav is asking, taking into account the denunciation of the convention by the Russian Federation, is it logical that we will face the issue of enforcement of court order? And do we have options for a potential implementation of the decision as well, which is, I think, something I would be quite concerned about.
Thank you. I think I will start with answering. I just would be very brief in answering, because while now we are at the active stage of consideration of the case, it is difficult for us to make to assess possible results of the case and how it will, how the proceeding will end. But I agree with Tamar. Many thanks for your presentation, for your thoughts, and especially regarding the correlation of the convention and the international humanitarian law. We also examining this part, and I even can say more that the Court of Human Rights also studying the application of the international humanitarian law within our application, within our case. And I fully agree with you that in result in this case, Ukraine and the Netherlands versus Russian Federation, we will see some developments in the court's approach in examination of the not only interstate cases related to the conflicts, but also individual cases, that because we know that not only a situation of conflicts was the matter of the court's examination within the interstate application. There are also within the individual cases, and I think we will see a lot of developments, including regarding the court's vision, the court's approach, how to apply the norms, the principles of international humanitarian law in during the consideration of the applications that are related or in the context of the events of conflicts. And regarding the question regarding the Yaroslav's question, it's for me it's like difficult to answer because the issue of implementation of the judgment, it will be the issues, and I think even we will have the challenges of implementation of the court's judgments. The Council of Europe and the European countries already are facing these challenges. We can see the problems with the execution, interstate applications, Turkey, Cyprus versus Turkey. I know now there are very huge, they were and still continue extensive discussion regarding implementation and execution of the judgment Georgia versus Russia too. I can say that for now the Council of Europe also is working with this issue, looking to working with the possibility to implement. From the part of Ukraine, I can say that given that the Russian government ceased to be the member of the Council of Europe, and is also now not the party to the convention since 16 September 2024, the execution, like the execution of judgment, it's like voluntary action. Yes, the court delivers the judgment, establishes the violation on the part of the state, and then the state is obliged, according to the convention, to implement the relevant judgment of the court. The Russian government, we can also recall several situations, even some individual cases refused to implement, even those individual cases that were related to against the Russian government. in the cases of the Russian nationals against the Russian Federation. So Ukraine now, for Ukraine at this moment, the judgments and even this decision on admissibility is more like instrument for further political and diplomatic actions, and also you can find the information from the Ministry of Justice that within that work, Ukraine is also working on the creation of a compensatory mechanism from the Russian government for those damages Ukraine has given the Russian aggression. But now it is all in the process. We understand that voluntary, at least for now, Russian government will not execute any judgments, and now we are looking for different possibilities how to create a mechanism to receive that execution.
Thank you so much, Margarita. It's been very interesting. We can discuss it further, but maybe Tamar would like to offer her insights as well.
I think from the execution perspective, Margarita perfectly addressed. I think I will look at the fact why this decision is particularly important for Ukraine. In my, again, understanding. First of all, the one thing is that, of course, execution can be delayed, but as in any proceedings, particularly when you have victims, victims have to be heard. And that's an aspect which is, I think, morally very important for Ukraine, the same way as it has been important for Georgia, but more, even more, I think the thing that what I feel quite often, perhaps a frustration from my Ukrainian friends, is that we woke up in 2022 realizing, but it started for them in 2014. So somehow for me, that decision is also recognition that it did not really start in 2022, but it really started, as Ukrainians are saying, in 2014. And that's also important for the victims. I think the second aspect there is that it is very, very important from legal qualification perspective and evidence being examined timely and discussed, because there could be issues that quite often when some of the evidence is not fresh in your mind, you do not perceive so much relevance of the evidence, particularly that's even more important when you think about the criminal aspect of similar cases. And last but not least, I think what is important is that this decision, of course, there will be the merits, and even if we wait for the execution and enforcement, and I think it will come, because if Russian Federation wants to return to the international community, it has to be part of the burden that they will have to enforce the decision by the international tribunals. I think it sets a very important context for Ukraine in other cases. As Margarita mentioned, there will be compensation mechanism, and it is decided on international level through the General Assembly resolution adopted in November 2022, which means that it also sets certain precedent how the aspects, how the violations in a jurisdictional perspective should be attributed. The second may be reflecting something in relation to Georgia. It can help also the cases in ICC. We have seen that in relation to Georgia, there has been a judgment in Georgia versus Russia merits, where a very specific episode of unlawful confinement of civilians was found as a violation of European Convention on Human Rights. And I don't know if it's by chance or it was deliberately that the International Criminal Court then issued arrest warrants specifically in relation to those episodes. And it triggered and helped the court actually to feel comfortable well, in my understanding, again, personal opinion, it helped ICC to feel comfortable in its formulations. And I see that this decision can also help the same way the future cases, which we will, and we know now that there will be cases before International Criminal Court for sure, including the issue related to children. Although it's a different episode, but we can see the same line relating to abduction of the children in Russia, Ukraine and Netherlands versus Russia case that we are discussing now. And similarly, perhaps it can be also helpful in litigation before International Court of Justice, where one of the cases, not the genocide convention related case, but previous case, a first interstate case taken by Ukraine against Russian Federation, actually relates to some of the facts which date to 2014. I stop here, although it also links to another interstate case, which we're not discussing now, which is Crimean case of Ukraine versus Russia.
Thank you so much, Tamar. Definitely, I think there will be little disagreement as far as the opinion you expressed goes, because clearly, as Yaroslav also asked, we might indeed face some challenges with respect to implementation of the judgment. However, it is mostly about creating the context and creating a legal judgment to which other judicial bodies can also refer. And in fact, Tamar, it is amazing that you mentioned the ICC arrest warrants, because the last question we have is, given the very recent ICC arrest warrants for the unlawful deportation of children, what implications can the ECtHR case have on potential ICC proceedings? So, in fact, you mentioned it with respect to Georgia, but the same question would be very interesting with respect to Ukraine. If Margarita wants to, or if Tamar wants to elaborate more, both of you are more than welcome, please. Both of you are more than welcome.
Okay, so I guess I go first now. So I think the implication for me is very clear. It will help. Undeniably, I think it will be help. It's yet to be seen apart, because right now, well, we know the case related to the arrest warrants are related to deportation and forcible transfer of Ukrainian children from occupied territories towards Russia proper. In my understanding, I mean, looking at the logic, how it was linked to our ECtHR interstate case towards the ICC, again, based on previous experience, the courts look at each other. I mean, it is a general rule that there is no hierarchy, but at the same time, the different forums do not want to contradict with each other. There is a general understanding of avoidance, what happened between ICJ and ICTY with the famous Tadic dicta. And undeniably, we see that if we follow the logic of how the cases, interstate litigations have been helping each other in a Georgian situation, I believe similar could be observed in relation to Ukraine. Of course, it will also depend on the facts, because I have to see yet, I haven't had the opportunity to read in detail the request of the OTP in relation to these arrest warrants, but it will be also relevant in relation to time period, which cases of war crime or perhaps even crimes against humanity will be taken up by the ICC.
Thank you very much, Tamar. If Margarita wants to elaborate a bit more, it will be our pleasure to listen to you.
Thank you. No, just I agree with Tamar, and I also share the opinion that the different international courts they like their proceedings, litigations, they complement each other, and I just remember that there was from the beginning of 2014 there was some like discussion that Ukraine's litigation in one court can exclude litigation in another international court, and I remember all those discussions. We have like several rounds of those discussions, but I do really believe that there is there is no contradiction between the proceedings before different courts, because those litigations, they are not like the similar. I agree with Tamar that everything depends on the facts, and also I also want to study more carefully this information regarding the arrest warrant, but it is really important, the facts, the surrounding facts, the period, the proceedings are different, and the purposes of the litigation, they are also they look like we have the more general, more global aim to to bring the Russian Federation to the international legal responsibility, but at the same time, each proceeding before different international courts, they have some peculiarities, differences, and I'm more for that opinion that they even help each other. Those two litigation, they will help each other, and they complement each other, but not to exclude the cases.
Okay, sorry. Thank you very much. I know I did say it was going to be a last question, but if you allow me to ask 2 more questions, I would be very grateful. So the first would be, I was actually inspired by what Margarita said about different fora for litigation. This case is a bit different, what I'm about to mention, but yes, it is generally, it is of course true that when a case has been litigated in one court, you cannot have the same case about the same issue considered in a different forum. But I was reading today, in fact, it was today when the UN Aviation Agency was about to vote on whether or not to consider reviewing the case of droning of the MH17 flight. If you have any information, or if you would like to comment in that regard, whether it would be helpful at all or not, that would be greatly appreciated. And then the last question I would like to ask would be mostly about the recent ICC warrant that Tamar has mentioned. In fact, someone wrote in the Q&A section, congrats to everyone with the ICC arrest warrant on Putin. So congratulations, but I know it's very recent, so I don't think any of us here have enough information about it because it's been quite recent. But if you have any predictions, I know it's not literally the topic of our today's webinar, but I think it would be interesting to hear your concluding remarks in this specific regard. So what chances do we have that ICC will indeed succeed in catching the war criminal?
Thank you. I'll start. once again, very brief in answer regarding these issues. I do really believe that ICC will succeed, and Ukraine works. You know that Ukraine now works closely with the ICC regarding the investigation and proceedings, and in order to also to use that forum for the international for the bringing of the Russian Federation to the responsibility. It won't be an easy. It is not an easy task. It's not an easy task. There will be a lot of challenges. Every state is facing before different international forums. A lot of difficulties, but in any case, first of all, it's up to Ukraine how to work to get the best result, and we have very encouraged team in the prosecution office. They are more responsible for the ICC. Also, Ukraine pays a lot of attention to the other international forums. So I hope I can. It's not like it's maybe my hope. I hope that Ukraine will succeed in International Criminal Court, and also we will also have the good judgment on the merits in our cases, and in Ukraine also will have judgments in International Court of Justice. But everything depends first of all on us.
Okay, so first issue related to, I think, forum shopping, because something which is unavoidable when you do an interstate litigation in different forums. There can be a challenge whether you are bringing the same as an applicant state, you are bringing the same one and the same case before different dispute parties. Thus, you are basically doing what they call the forum shopping. So you try to do maximum, and you are abusing your power as an applicant state. My observation there, I think they're legalistically looking at that, because we had that challenge in Georgia as well. However, the court on the admissibility level, European Court of Human Rights, dismissed that discussion, because then the respondent state, which was present, Russian Federation, actually raised that issue in relation to parallel proceeding before the International Court of Justice and before European Court of Human Rights. Unfortunately, or luckily, because the ICJ case has been stalled due to admissibility challenges related to exhaustion of the negotiation elements in Georgia versus Russia, that aspect hasn't been answered by European Court of Human Rights in our case. However, I think the answer is very clear. If you are able to differentiate the disputes based on the violations, even if you are using the same facts, there will be no challenge of the forum shopping, particularly since also ICC and European Court of Human Rights are two different forums. One relates to interstate litigation, and the other is related to individual criminal liability. Therefore, even the understanding of the dispute is not per se the same, and it is quite directly avoidable. Now, in relation to the second question on the arrest warrant, I think it has yet to be seen. I think it's a great success for Ukraine, great success for OTP and ICC. Couple of maybe again personal reflection. First of all, I think for Ukraine it's very clear that proceedings starting in ICC doesn't mean that Ukraine will not pursue also another initiative, which we have not mentioned, that is the establishment of the special ad hoc special tribunal for the crime of aggression, even if the ICC continues to indict Putin or other members of the famous Troika, which is the Prime Minister or the Minister of Foreign Affairs of Russian Federation. Still, the logic that there should be a special tribunal for the crime of aggression so vocally appealed for Ukraine still stands, because it's a different crime and it does not overlap. This is the first observation. The second, of course, what are the processes we go in the ICC? We know based on the statute of the ICC and the rules of procedure of ICC that the person after the issuing of arrest warrant to the maximum extent based on the practice of the ICC can be brought without his presence. You can do a confirmation of the charges, so he can become from the suspect and accused. But for the trial, he has to be present. We cannot try the persons in absentia. So the key question would be whether it will be the ICC, or if the ad hoc special tribunal for the crime of aggression is formed, who will get first to the person. But what I think already the arrest warrant does, based on very classical example of ICC's practice in al-Bashir, it is a clear message for the international community that this person is charged with, suspect in the commission of the war crimes. It shouldn't be business as usual with the leadership of the Russian Federation. It inevitably means that through the cooperation obligation under the Rome Statute, the members of the ICC will have a legal obligation if the president of the Russian Federation or the relevant lady, and I think her last name is Boba, visits state members of the Rome Statute, they have to surrender these people to the court. Already that, I think, is a significant step forward because it puts them in an uncomfortable situation. The next thing is not only about Ukraine. I agree with Margarita that Ukraine has to do a lot of things, but international community has to do a lot of things, because now it is the reaction of the international community which matters, of the international organizations, of international states feeling obliged to make the leadership uncomfortable and making them understand that they perceive them as war criminals. Maybe it's very subjective from my side, but that's the short-term result, what I see from the arrest warrants.
Thank you so very much, Tamar, for this reflection. And thank you, Margarita. I loved listening to the expression of hopefulness, because we all know that, and we have seen it before, all states who have been victims of Russian aggression, basically, that international justice sometimes does not work. But me, and especially after hearing the both of you, I am hopeful that finally the human rights law and the international criminal law will somehow go hand in hand in order to manage to prosecute all the alleged war criminals, those who committed international crimes on the Ukrainian territory. I do believe that this is the time where all of us should be hopeful, and all of us, especially in the field of international law, human rights, IHL, ICL, we should all unite our forces to try to combat all the crimes that are currently taking place in Ukraine. So let's be hopeful. It is very nice that today coincided also with the arrest warrants that ICC issued against Putin. As Tamar said, I think the least we can do is just try to make them feel a little bit more uncomfortable. On this note, I would just like to thank you very, very much for the time that you found to join this webinar, regardless of your busy schedule. Thank you so much for the interesting insights you provided. And thanks to all the participants who joined as well. and who asked interesting questions. I would love to see you again in one of our future webinars as well, because the Ukraine program of the platform will be organizing series of webinars. So you are more than welcome to attend again. So once more, our distinguished panelists have been Margarita Sokorenko, who is the agent for Ukraine at the European Court of Human Rights, and Tamar Tomashvili, the IHL expert for International Development Law Organization. I am Jabauri, the Ukraine Program Director at the Platform for Peace and Humanity, and I'm very grateful for the opportunity to have enjoyed this interesting webinar with you. Have a very good evening or a very good night, depending on where you are. Thanks a lot.
Thank you.
Thank you.